As promised, let's bring you analysis on this. We are joined by the political analyst, Thobani Zikalala. Mr. Zikalala, thank you for your time on the program. Perhaps let's start with a bigger constitutional question here. So we now have Parliament trying to exercise its Section 89 accountability function on one hand. On the other, a president that is essentially challenging that process in court, and the courts themselves that are being asked to determine whether Parliament can indeed proceed, while another legal challenge is still pending. Just at what point does judicial intervention stop being about protecting procedural fairness and start potentially interfering with Parliament's constitutional responsibility to hold the president accountable?
Good evening, Mtolisi, and good evening to your viewers. I think your question hits right at what is at the heart of what is a problem with these applications by the president, because the president is seeking to have the courts determining or almost exercising what we could call judicial overreach, interfering with the processes of Parliament. But this is not real. On the side of the president, the applications are not really sometimes about the procedural issues or substantive issues. It is a way of trying to delay the public spectacles that come with the impeachment process. The courts must be cautioned, I think, with the finding themselves exercising judicial overreach and interfering with the process of Parliament, because ultimately the processes of Parliament are not legal processes. They are political processes, of course governed by the Constitution, but at the end are political processes, and the president is trying to find a way. I mean, president in trying to find any way that he could delay this political spectacle that will hit at his integrity. Being the first president, if my memory serves right, in the democratic process, in the democratic dispensation, to be in front of a Section 89 impeachment committee. And no one wants, no president, no sitting president or no sitting official of the state wants to go through this process. We've seen this process before when it impeached your Judge John Shope, your public protector advocate Mkwabane, in terms of how it hits at the credibility and integrity of the officials involved. So the president will try to find any means, but the courts must be cautioned, because in this case, in terms of what the courts are being asked and what they've ruled on, I hold the opinion that the courts have now entered the political terrain and are now, in a way of their judgment, interfering with the processes of Parliament.
And now that you've used that analogy, I'm forced to, squeeze this question in, Mr. Zikalala, whether does tomorrow's application perhaps also set, precedent beyond President Ramaphosa? Could a future president use litigation to effectively suspend an impeachment process?
I mean, it's the precedent-setting type of application, I would put it that way, because, I mean, in the past, of course, we've had presidents like your President Jacob Zuma and the like. I mean, even though it was not an impeachment process, but trying to use the courts in trying to delay a public spectacle, a political spectacle that seeks to hold them accountable. If you remember, the president at the time, looking at the State Capture Commission, had a similar applications in terms of recusal of one official of the commission, or the idea of who must appoint the sitting presiding officers. In this case, you've got the president who's putting applications to delay to prevent Parliament from appointing a particular evidence leader. Of course, I mean, the president has a right to be prosecuted or be led in evidence by a person who does not carry any unnecessary biases. But the other issue is that the president is alleging that Griffith Madonsela will carry some conflicts of interest because he has done work for the president, for the ANC before. I mean, I think I heard in the past when this matter was discussed by the members of the impeachment committee, where they raised a question which I could raise also as a layman, that if we are going to say legal professionals cannot participate in processes because in the past they've done legal work, then which for example, legal professional or legal practitioner will be the one who's suitable, because any argument could be raised by about any of the legal professionals that this one doesn't like this one has an opinion on this one has done work for this political party, therefore they carry a conflict of interest. So I think for me, as I said in the beginning, President ubambelela ngesidindi ukuzama ukwenza ngayo yonke indlela to have a way where this process is delayed so that he does not have to sit in a public platform and account and be scrutinized and have his credibility be put in question.
And we're just about out of time for this question. So, now we have President Ramaphosa's argument that we have is that essentially that he cannot be subjected to a public impeachment process, while the very Section 89 report underpinning that process is still being challenged. And to also throw a spanner in the works is what you've just mentioned now, that question around appointing an evidence leader. But Parliament comes and says it is duty bound to proceed. How would you then distinguish a legitimate demand for procedural fairness from a legal strategy, sort of, but also somewhat has the practical effect of buying the president more time?
I think it will be very difficult to separate the procedural application of the issues of procedural fairness to a legal strategy. Because when one litigates, you look at loopholes in the case or in the processes of those who seek to prosecute you that could delay or could render the process unable to continue. In this case, I mean, yes, the courts have decided that because the president is still approaching the courts to review this process, then the parliament can continue. But the issue, which again we say the court has adjudicated in this case, but President Ramaphosa had all the time in the world to review the report, and he didn't, because he felt that Parliament had dealt away with the report. Now that the process of dealing away with the report has been deemed unconstitutional, he's then finding new ways of trying to have this impeachment process delayed. And I think, as I said, it's a legal strategy. But of course, when you employ a legal strategy, you must cling upon a particular legal point, and in this case, it's an issue of procedural fairness.
All right, Thomas, thank you so much, ever so much for your insights. Always great to chat. That's political analyst Thobani Zikalala joining us there for his insights on the program.